Thank you, Jim, for that introduction. I should probably just, with that, just go straight to Q&A. But I won't, because I have actually prepared a little something to talk about here. But I do want to leave some time and answer any questions you might have about either the subject of this talk or really anything else. And I'm happy to talk about my experience with President Clinton, if that's of interest. That will not be the subject of this talk. Because the Supreme Court of the United States is giving us lots to talk about these days. I appreciate the opportunity to come talk to all of you about the Constitution, particularly because I am what is charitably known in certain circles, including my own home, as a non-lawyer, my wife being an actual lawyer. Since this book came out in 2010, I've been running around the country impersonating a lawyer or a constitutional scholar, occasionally playing one on TV, generally practicing constitutional law without a license. So if there's not a law against that, there probably should be. I'm here today to talk about a rivalry. I guess I've written 2 books now on rivalries. As Jim said, I wrote a book on Lyndon Johnson and Robert Kennedy, and now more recently I've written this book about Franklin Roosevelt and the Supreme Court. And it's this rivalry, the second, is what Justice Robert Jackson once called the most dramatic, persistent rivalry in American history, and that is the rivalry between progressive, or at least activist, presidents and conservative Supreme Court justices. This goes all the way back to Jefferson and Marshall. I understand that you heard an excellent talk about that earlier today, and I was only sorry I was still in the air on my way here at that time. Lincoln struggled with this. Jackson before him struggled with this. Both Roosevelts after him struggled with this. And we see now President Obama struggling with the same dynamic. So conveniently for our purposes, this has been in the news. President Obama just a few weeks ago had a few things to say, as I'm sure you heard, about his own rivalry with the conservatives on the Supreme Court. I'll talk about that a little bit, as I expect it's been on your minds. It certainly has on mine. The Roosevelt analogy, as I'm sure you've seen, has been all over the place in the last few weeks as the Roberts Court considers the fate of the Accountable Care Act, of the Health Care Act. Although, of course, you have not heard that analogy from President Obama himself. And there's a reason for that, because it didn't turn out too well for Roosevelt. One does not seek to analogize to Roosevelt's biggest political defeat. Because Roosevelt's experience really demonstrates, more than any event in our national history, the destructive power of a battle between these 2 branches of government. That power can be measured more than anything by this reversal of fortune. Consider this. In January 1937, Franklin Roosevelt took the oath of office for the second time. He was really at the pinnacle of his power, really at the pinnacle of presidential power, period. He had won, as I'm sure you know, by a landslide in 1936, a landslide re-election. And it was not only a huge victory for Roosevelt himself or for the New Deal, but for the Democratic Party generally. And the 96 senators, of course, at the time, 96 senators for 48 states, the 96 senators that were seated in January 1937, of those, 76 were Democrats. 76 out of 96. And not even all of the remaining 20 were Republicans. So we were closer to one-party rule than the nation had been since Reconstruction. Now, at that time, Carter Glass, who was a Democrat from Virginia, not particularly sympathetic to Roosevelt, said, and this was not necessarily a compliment, he said, "Why, if the president asked Congress to commit suicide tomorrow, we'd do it." Now, President Obama might occasionally wish the same thing. I'm not so sure they would oblige. Now, 6 months later, fast forward 6 months, Roosevelt had suffered the most spectacular defeat of his political life. The New Deal was stalled, his popularity had gone into its steepest decline, and a new conservative coalition had emerged in the Congress to stymie the New Deal. This is the moment that Alan Brinkley of Columbia identifies as the end of reform. This was really it, the watershed moment. Now, it was probably coming anyway. These conservatives weren't created in this moment, but their coalition was catalyzed by Roosevelt's decision to pack the court at the beginning of his second term. At that time, the Saturday Evening Post wrote that Roosevelt still commands support, but not the old awe, reverence, or idolatry. So what happened? Well, I've already tipped my hand, and you already know the answer. What happened in that intervening 6 months was the court fight, as it was known at the time, the court packing fight as we know it. And this is mentioned in many, many accounts of the period, and it's rarely avoided. But my feeling as I got into this was that it was never really fully explained. This is why I decided to spend several years writing a book about this, because it tends to get reduced to a neat, pat parable of second-term overreach. In 2005, when President Bush announced that he had political capital and he was going to spend it, and he launched a crusade to privatize Social Security, as you'll recall, that's when the court packing analogy reemerged in that moment. Here was the president in his second term overreaching. And so this is what it has generally been reduced to. And what we get out of this is a kind of tale of two FDRs. You have the FDR of the 100 Days, the FDR of the early New Deal that we all know and many of us love. And then suddenly, at the beginning of his second term, he loses his head. He wreaks revenge on the Supreme Court. He is so overcome by arrogance and hubris after his landslide re-election that he can't contain himself. 6 months later, the court packing plan is defeated. He goes back to being the Roosevelt we all know, many of us love, and helps to win the war. Now, that never really washed for me. I mean, does someone like Roosevelt simply just lose his head for a period of 6 months? Is hubris a sufficient explanation for this really incredible decision to do something as seemingly radical as to expand the size of the Supreme Court overnight from 9 to 15 so that you can tip the balance dramatically? And as I got into this question, I felt, A, hubris was not a sufficient answer for reasons that I'll explain, but secondly, it came to seem to me that this really was the key in many ways to understanding Roosevelt in the years before the war. That this was the defining conflict of Roosevelt's presidency in the run-up to World War II, which of course changed everything. And the reason for this is that the struggle, as both sides in the conflict saw it, was a struggle for the very survival of democracy. Roosevelt and his supporters believed that if they could not get these New Deal programs past the conservatives on the Supreme Court, that there would be a total economic collapse in the country that would make the Depression look like a cakewalk. If they couldn't do something about unemployment, if they couldn't do something about the banking system, if they couldn't do something about working conditions, if they couldn't do something about agriculture, if the federal government was denied by the court the powers to deal with these things, there would be the kind of collapse you had seen in Germany, and you might very well see the sort of conditions where out of the ashes would rise a dictator. This was very much on Americans' minds at the time. And this was on the minds of the conservatives in the country as well, including the conservatives on the Supreme Court. The feeling was on that side that if Roosevelt, who had a rubber stamp they felt in the Congress, which had never really said no on any major issue to Roosevelt through his first term, that if he could get all of this stuff through the Congress and roll right over the Supreme Court, then we would actually have a democracy, a dictatorship in America. That there would be such centralization of power in Roosevelt's hands, we would have one-man government. That was the mantra on the right, one-man government. And we would effectively have our very own American Hitler or Mussolini. So both sides saw this as an apocalyptic, existential crisis. And that's why I think it's a useful conflict through which to understand those times. And I also think, as I've already indicated, that it's useful in a different way in understanding our own times. When the conservative justices on the Roberts Court question whether the healthcare industry is actually interstate commerce, and they grill the Solicitor General about the wisdom, not just the constitutionality of the healthcare law. When the Supreme Court's election year docket contains political dynamite not only in the form of the healthcare case, but also the immigration case from Arizona, the Texas redistricting case, all of which pit the court's conservatives most likely against a progressive president, at a time when the Tea Party movement is holding the equivalent of Bible study classes around the country on the Constitution. and when candidates are making pledges to save the Constitution, from Barack Obama. When all these things are going on, you can see that the conflict at the core of Roosevelt's court fight is still unsettled. That this argument, which goes all the way back to the founders, and you probably heard something about this earlier today, this fight over the meaning of the Constitution, over the limits of governmental power, if there are to be any, and this question of whether democracy can be made to work in times of economic distress, these are still very live questions. And in times of severe economic distress, and we're in those times now, although this is, of course, nothing like the 1930s, that question, which always simmers, becomes explosive. And so for the next 10 minutes or so, I want to take us back to the 1930s to talk a little bit about this conflict. And I want to be sure that I leave time, as I said, for your questions. I want to begin with one of the protagonists or antagonists in this fight, and that's, of course, Franklin Roosevelt. I know I don't need to introduce him to all of you, but I do want to talk about one aspect of Roosevelt that maybe you don't know quite as much about, and that is Roosevelt as a lawyer. If you don't know that he was a lawyer, you're forgiven because he didn't really want anyone to know that he was a lawyer. He did not love the law, per se, and did not love law school. He left early. He did pass the bar, and as you probably know, practiced a little bit, sort of. But he had his eyes on politics, on public life. And as Robert Jackson, who served as his Attorney General before being nominated for the Supreme Court, as Jackson wrote in a private memoir, he said Roosevelt didn't really like the judicial process with its slow movement. He wanted shortcuts. He was an executive personality. He wanted to get things done. And he certainly cared whether something was constitutional. It's not as if he was unconcerned with the Constitution, but Roosevelt was a believer in what was proudly at the time called the living Constitution. We don't talk much about that anymore on our side of things. But he believed in the living Constitution. He believed in the Constitution of Holmes and Brandeis and Cardozo, and also Robert Jackson, who wrote that the Constitution, according to the framers, the Constitution contemplated a really effective government. Roosevelt believed that the founders in their wisdom had given the national government power to solve national problems. They wanted the American experiment to succeed. They didn't want it to disintegrate. And that was his understanding of the Constitution. And so he did not see any inherent conflict between the New Deal and the Constitution. He didn't see that there was actually a conflict there. He did see, however, that there would be a conflict between the New Deal and the conservatives on the Supreme Court. So let's talk about those antagonists for a minute. This group of justices at the time was known, as many of you probably know, as the Nine Old Men. Maybe a little unfair, but in 1936, the average age of a justice on the court was 71, which to that point was the oldest in history. And keep in mind, this is 1936, and age, the lifespan was not quite what it is today. And there was a general feeling in the country, particularly among the politically engaged, that age influenced outlook. Even though the oldest justice on this court was Brandeis, who was one of the leading liberal lights in the country in any realm, generally these were seen as men from another era. They were 19th century men. In fact, when Charles Evans Hughes was a student at my alma mater at Brown, they had two closets in their dorm. They had one for their stuff and one for the coal that they would shovel into their coal-burning stove. And they had a servant in the dorms called a slave. Not an actual slave, but there wasn't quite any sensitivity to calling someone that. Justice Sutherland, who was another one of the conservatives on this court, was born in England before Gladstone or Disraeli had served as Prime Minister. And Justice Van de Vanter, another one of the conservatives, was old enough to have remembered as a child watching Lincoln's funeral procession. And here they were in the world of the 1930s. And many of them really did adhere to a Gilded Age notion of the Constitution, a constitution of limitations, in which private power, the power of the private sector, corporations, was essentially unfettered. And this court, with some notable exceptions, had been a powerfully conservative force in American life for 50 years. And it was typical of leading thinkers about the court to say that inherently the Supreme Court is conservative. They had never lived through a Warren court. And so there was the feeling that this was simply an obstacle to progress in the country, and that it was inherent, and there were all sorts of ideas percolating about how to change the dynamic, the balance between the branches of government, or how to reconstitute the Supreme Court or strip away its powers so it could no longer sit at the center of our national life, judging the decisions made by the President and the Congress on the wisdom of their legislation. And so you had a court that was really pretty similarly divided to the one that we have today. You had three very solid liberals, Brandeis, Cardozo, and Harlan Fiske Stone. You had a Chief Justice in Hughes who tended to side mostly with the liberals. You had four hardcore conservatives who were known as the Four Horsemen of the apocalypse. And then you had a swing justice, a Kennedy, if you will. His name was Owen Roberts, and he figures prominently into the court packing fight. Now, in January 1935, to sort of skip forward, the court begins outlawing the New Deal. It takes this long for the New Deal cases to start to get to the court. And in early 1935, it knocks down a piece of the National Recovery Act, of the National Industrial Recovery Act, the NRA, the National Recovery Administration. Knocks down a piece of it, and in May, it kills the entire thing, which had really been the centerpiece of New Deal industrial policy. The court has begun, in the words of one Republican newspaper, to throw this revolutionary nonsense into the Potomac where it belongs. And it proceeds in the matter of several months to knock down not only the NRA, but in January 1936 to knock down the AAA, the centerpiece of the farm program. It knocks down a state minimum wage. It knocks down a coal act. It knocks down a municipal bankruptcy act. At the state level, the local level, the federal level, all of these efforts to reckon with the Depression were being knocked down by the Supreme Court as inconsistent with any one of a number of constitutional doctrines or new ones that they were creating. Stone complained in a letter to Felix Frankfurter, who was still up here at Harvard Law School. He said, "We're creating new doctrine faster than I can keep up with it." They were also resurrecting old doctrines, some of which had been declared dead in the first decade of the 20th century. They were coming back to life to knock down these New Deal programs. It was not simply the fact of the decisions, but it was the tone of the decisions or the opinions that created a sense of growing crisis in Washington. Justice McReynolds, who was probably the most unsympathetic man ever to sit on the United States Supreme Court, vicious racist, anti-Semite, refused even to talk to Brandeis or Cardozo, refused to sit next to them in the court photographs that they took every time there was a new court. McReynolds, when one decision on monetary policy actually went by a 5-4 vote in favor of the administration's position, a rare win for Roosevelt, McReynolds sat up on the dais, pounded his fist, and rather than read the actual dissent, began to just fulminate and said, "The Constitution as we know it is gone. This is Nero at his worst." Reported on the front page of every newspaper. Even Justice Scalia, I think, might hold back from that sort of rhetoric, although I wouldn't put money on it. Privately, maybe. Now, so it's not a surprise then that over this period of time, that not only the Roosevelt White House, but a range of others around the country begin to grope for some kind of solution. The country, as I write in the book, becomes kind of a rolling constitutional convention in 1935, 1936. And there are hundreds, literally, of proposals put forward in the Congress and even more around the country of what to do about the Supreme Court, stripping away its powers, giving Congress the power. This was a popular one, by constitutional amendment, to allow the Congress to veto any Supreme Court opinion that it didn't like, making the Congress and not the court the last word on the Constitution. There were other proposals for age limits for Supreme Court justices, term limits for Supreme Court justices. All of these things were floating around the country, and many of them were very popular, according to polls, and many were popular in the Congress. Now, Roosevelt considered many of them. There was a secret, very quiet project going on in the Justice Department where all of these options were being considered, and memos of 65 pages in length were being produced for the Attorney General and then for the President to review. And one by one, Roosevelt rejected all of these sorts of amendments because ultimately he came to the view he had held from the beginning. As I said, he didn't really think there was a problem with the Constitution. The problem was this group of guys on the Supreme Court. And how can we do something about them without doing damage to the fabric of the Constitution or the balance of powers as it's intended in Roosevelt's view among the branches? He also rejected the idea of waiting. I said that this was an old Supreme Court. It was not unreasonable to think that, as one Democratic senator said privately to Roosevelt, "Father Time is on your side." And Roosevelt didn't think so. He knew that McReynolds, who I mentioned, had said, and this circulated all around Washington and was reported, that McReynolds said, "I will never leave the Supreme Court so long as that crippled son of a bitch is in the White House." This is what he was up against. And he also felt, as I said before, that unless something could be done about the Depression, that the economy would never recover, and that we were headed for violence in the streets, a wave of violent sit-down strikes, as you may know, across the nation, 35 and 36. Roosevelt didn't feel that he had time. He didn't feel that Father Time was on his side. And so, immediately after his re-election, he agreed with his Attorney General Homer Cummings on a plan to pack the Supreme Court. Now, this is an idea that had been in the air for a long time, but always discounted, publicly always discounted by Roosevelt. There was something, as Roosevelt once told his cabinet, distasteful about the idea. But it was not unprecedented. The number 9 does not exist in the Constitution, in this regard anyway. I haven't scoured the document to look for other numbers 9. But the founders did not tell us what size the Supreme Court is supposed to be. And so it went up and down over the course of the 19th century. And not only was the court packed from time to time in this fashion, although not quite as dramatically as Roosevelt proposed, Congress would also, as a slap to a president, reduce the size of the Supreme Court so that presidents wouldn't get to appoint anybody. They did this on his way out. Adams and the Federalists did this to Jefferson, reducing the size of the Supreme Court pending the next retirement. And it was done to Andrew Johnson again in 1866. But the court had bumped its way back up to 9 in 1869, and it had been there ever since. And so there was a feeling of permanence. And as I said, not that many people knew that this is actually something that would be in play. And so while Roosevelt could look to history, that history didn't feel real to most Americans, maybe because they didn't get taught in elementary school. And so Roosevelt and Cummings came up with a plan, the rationale for their plan. They decided against a frontal assault, an ideological assault on the conservatives on the Supreme Court, even though everybody knew what was going on in the country. This was all played out on the front pages of the papers. But they came up with a plan to suggest that this was about the efficiency of the court, that these guys were old and they were getting slow. And they said, you know, we need new blood on the Supreme Court. We need a jolt of energy. They talked in these sorts of terms. And they came up with a plan that said that for any justice or any federal judge, in fact, this concerned the entire federal judiciary, anyone over 70 who refuses to retire, the president will then have the right to appoint a new judge to essentially sit by the side of the old judge and help him with his work, which, if no one retired, would give Roosevelt 6 appointments overnight. He reluctantly agreed to a ceiling of 15 on the Supreme Court, because, you know, I mean, you could have 9 over 70, right? You could have a court of 18. He decided 15 was probably good enough. It would give him a massive liberal majority. The problem was, when he launched this plan on February 5th, 1937, he had failed to do the work that he had done on previous big things that he had tried to do. And that was, he didn't bring the country along. He didn't bring the Congress along. He had cooked this up in secret. He believed the secrecy was going to be part of what allowed it to pass, that he would essentially spring it on the Congress. And he would even write the bill, which his White House and his Justice Department did. And it would be over overnight. You would have 15 on the court, no more problems. But it was clear from the beginning, as the morning of the 5th, he brought in first congressional leaders, then he brought in his cabinet, told them about his plan minutes before he was wheeled into the Oval Office to tell the press corps and the nation. It was clear that there was a lot of immediate discontent, not because they were unsympathetic to his purposes, but because they did not like the way that this plan was justified. Others had pet ideas, I mentioned some of them before, that they would have preferred, but there was an openness to this idea. If only Roosevelt had been honest about his intentions. They didn't like the sneakiness of it, and they were right. to question that, because as soon as the plan was launched publicly, the idea that the court was behind in its work was disproven immediately, in part because Chief Justice Hughes allowed the leading conservative reporter from the Washington Post to come by his chambers and fed him statistics, which then wound up on the front page of the Washington Post the next day. So Hughes was working behind the scenes to undercut this plan. But others saw these statistics as well. And so the plan began with what Sam Rosenman, Roosevelt's speechwriter, called a black eye. And Roosevelt's motivation, which had previously seemed to be so straightforward, was really called into question. And it hurt him from the beginning. The case that he made for packing the court was misleading, it was unconvincing. No one bought this picture of congested court dockets and of aged justices refusing to hear important cases because they were too old and tired. No one bought it. And he spent a month sticking to this rationale before he seized the fighting issues, as his advisors urged him to do. And so what he did then, and we will move quickly through this so we can get to the Q&A, is he precipitated a political crisis with the Congress. What had begun as a constitutional crisis between the president and the Supreme Court, or the president and Congress on one side and the Supreme Court on the other, became then a political struggle between the president and the Senate. And even though Roosevelt faced an uphill battle, which only got steeper over the course of this period of months, Roosevelt kept fighting. He refused to compromise, because what he saw now was that if he gave in to the calls for compromise, that he would have given in to the Senate at the beginning of his second term. And he thought the conservatives in the Democratic Party and the few remaining Republicans will cause me no end of trouble. I cannot yield. And so this cost him very badly. And it cost him especially once in the middle of this fight, the Supreme Court flips. Owen Roberts, who I mentioned before, switches. As some of you probably know, this is the famous switch in time that saved 9. In the heat of the court fight, the Supreme Court, confronted with a minimum wage law from the state of Washington, which is identical to the minimum wage law from New York that they had knocked down 9 months previously. 5-4 against the law in 36, 5-4 in favor of Washington State's law in early 1937. The justice that switched was Roberts. He would insist to the end of his life that he hadn't really switched, that you could distinguish these two cases, but there aren't too many believers in that proposition then or today. And then subsequently in April 1937, the court, in spectacular fashion, upheld the Wagner Act, the National Labor Relations Act, which everyone, including Roosevelt, thought was doomed. And in May, by a narrow margin again, the court upholds Social Security, also seen to be the policy equivalent of a mark ban. And so Roosevelt suddenly finds, in the middle of this fight, that he's getting the results from the court that he wanted. And a lot of people around him believe that it's because he threatened the court. In fact, there are a lot of people today who believe that. My own view is a little more nuanced, and I'll get to that in a second. But Roosevelt was told by most of the men around him, you've won, declare victory. Stop this fight, which is causing you to hemorrhage so much politically. Roosevelt again said, I cannot yield to these opponents in the Senate. The Senate Majority Leader, Joe Robinson, this old bull of a man from Arkansas, who had been a pugilist in the Senate and a pugilist outside the Senate. He was famous in Washington for having punched a couple of guys out on Chevy Chase Golf Course and Chevy Chase Country Club. This was a big, tough guy, self-educated, whose dream in life, once he got out of the Senate, was to be on the Supreme Court. And here's one of the great ironies of the court packing fight, is that Robinson, who was no real fan of the New Deal, he was a Southern conservative, really, carried the whole thing through almost physically on his back, was openly promised a Supreme Court seat by Roosevelt in 1935. Roosevelt looks at Robinson and sees, I don't want to appoint this guy, he's a conservative. I need to, if I'm going to have to appoint him, I want to outnumber him. I need all of these justices. I can't compromise and take 2 justices like Robinson's telling me to take, because one of those justices will be Robinson. The other will be a liberal, and they'll just cancel each other out. So these two are tangled up by their public promises and by Robinson's aspirations. But finally, the situation has gotten so dire by the summer of 1937 that Roosevelt yields and says, Joe, get me whatever you can. I have to be able to save face. And so Robinson begins to collect IOUs. He's sort of Lyndon Johnson before Lyndon Johnson. He's this great political operator. He's pulling IOUs from everywhere. It's starting to look like he can get this thing through. So in July of 1937, in one of the greatest heat waves to hit an already hot Washington, D.C., believe me, Robinson begins the Senate debate over the court packing bill. And he's standing in the well of the Senate, and he's pounding the podium, and he's shaking his fist at his opponents around the floor, and at people in the galleries who are shouting down at him, collapses on the floor of the Senate, turns purple, and is carried outside. He's given a glass of milk. He's told that he should probably go spend the rest of the day at his apartment, which he does, and the next morning is found dead on the floor of his apartment with a copy of the Congressional Record in his hand. And with Joe Robinson dies any chance of a compromise emerging. And so everything after that is denouement. The court has changed. The Congress is riled up with anger toward Roosevelt, and he never really recovers with respect to the U.S. Congress. This conservative coalition that has arisen to fight him on this plan is the conservative coalition that year after year stymies any hope of real and meaningful reform. So this was, if it was a victory for Roosevelt, it was a costly victory. Roosevelt would insist to the end of his life that we lost the battle, meaning we didn't get to pack the court, but we won the war. The court switched. I said I would come to this, and I will before I close. And that is that Roosevelt couldn't have known at the time, but the vote taken in conference in the Supreme Court on the minimum wage law, the first switch before the others that followed, that vote had been taken in the fall of, or at the end of 1936, right after his re-election, and a couple of months before he launched the court packing plan. So you cannot, if you reconstruct events in real time, attribute Roberts' switch to the court packing plan. However, I do my best to reconstruct the complex and kind of opaque character of Owen Roberts in my book. And I think that what can be said is that Roberts cared more about his public image than any of the other justices did about theirs. He was very much a man about town. He was the youngest justice at 60. And when the court began to do what it was doing, and Roberts had sided with the conservatives, most of the anger came down on his head. In the same way that people like me get mad at Justice Kennedy when he goes with the conservatives. You know what Scalia is going to do, you know what Thomas is going to do, but you hope you might get Kennedy, and then you don't, and then you're mad at Kennedy. And that's what happened to Roberts. And so Roberts suffered greatly, according to all who knew him during this period. And it's quite possible, although we can never say for sure, that what Roberts really wanted was a shot at redemption. And he took that in the spring of 1937. Now, the reason that Roosevelt could be said to have won the war is because the court changed essentially for good, at least for a number of generations. The reason we call this the constitutional revolution of 1937 is because it endured, because the court was transformed by Roosevelt's appointments. In short succession, the conservatives began to leave the court or die, and they were replaced by men like Hugo Black, Felix Frankfurter, Robert Jackson, William Douglas. And by the time Roosevelt dies, he has appointed 8 out of the 9 justices on the court are Roosevelt appointees. He's appointed more justices than anybody since George Washington. It helps to be president 4 terms, or most of 4 terms. Now, I said again that the argument is an enduring one, and I think that in closing, the argument that we heard, the oral arguments on the ACA, the nature of the justices' question, these things remind us that stare decisis, or settled law, or precedent, these are not immutable laws of physics. They are maintained or not by human beings, which is why it is possible now, for the first time since 1937, that the court will actively, on the basis of the Commerce Clause, be back in the business of judging the merits of laws passed by the Congress, second-guessing the economic policy decisions of the Congress and the President, really for the first time since 1937. Now, how much this has to do with either new or old constitutional understandings, as opposed to what Justice Stone called economic predilections, is something that even the justices themselves probably can't speak to, may not be able to gauge themselves. But the rest of us will have to judge for ourselves. And one thing, the only thing that's clear right now is that the argument's not over. Roosevelt anticipated this. We won the war, he said, but he understood that each successive generation would have to wage and hopefully win that war for itself. Thank you.